LaLone with Fishman Stewart. We're going to start our webcast in about a minute. We're going to let participants to join us now. So meantime, you can get seated in there at your comfy of your home, and we'll get started in about a minute, okay? Okay, we're going to get started now. We see participants are coming in from around the country. Good morning. My name is Doug LaLone. I'm a partner with Fishman Stewart. Today is our first webcast we'll be bringing to members of the intellectual property community. We are joined here today with a couple of our partners, and we will introduce them in a few minutes. First, just a little bit of background about Fishman Stewart and an overview about our webinar today. This is going to last for about 30 to 40 minutes. We'll be taking questions from our panelists. Our panelists will be answering questions by our audience today. Our members here today are Paul Ratzmann, Melissa Atherton, and Michael Fluhler. Raise your hand. You should hopefully be able to see our names at the bottom of the screen there. We're all partners at the law firm Fishman Stewart. We're an intellectual property law firm in Troy, Michigan. We service middle market clients around the country, helping them with their intellectual property needs. Today's webinar was brought about as a conversation we started having about a week ago with our firm on how we can reach out to the innovative ecosystem throughout our country. This is a time during the COVID crisis where people are in home, we're working from home. As you can see, we are in our basements working from home. That's where we're broadcasting here today. We're using Zoom technology to bring this webinar to you today. This is the first of several webinars. We will be rebroadcasting this webinar later this week on Thursday. It'll be a new live webcast starting at 1 p.m. A little bit more about how to use the technology today. If you haven't used Zoom before, you'll see at the bottom of your control pad a tab called Q&A. You can type in a question to our panel. Our panelists will see that, and we will try to get to your questions here today. There's also a chat taskbar also, where if you want to create a chat back and forth within with the attendees or with the panelists, you can create a conversation in the background. So please feel free to join in and participate with us today. We're looking forward to hearing from you. So a little bit about our panelists. Let me introduce first Melissa Atherton. Melissa has worked at Fishman Stewart since 2011. She was first a legal intern, then an associate, and she is now a partner practicing in our trademark practice group. She helps clients develop their copyright and domestic and foreign trademark portfolio and implement same in an efficient, cost-effective manner. Thank you for joining us, Melissa. Paul Ratzmann is a partner at Fishman Stewart, and he's been with the firm for 7 years now. He's a patent attorney practicing in various technology fields, including biotech, mechanical, aerospace, and electromechanical arts. Paul, thank you for joining us today. And Michael Fluhler is a partner with the firm. He's been with us for 6 years now. He's a patent attorney practicing in patent prosecution in multiple fields and technology, as well as he litigates IP cases in a variety of mechanical and computer technologies. He has extensive experience in IP licensing and leads the practice group with respect to licensing of technologies. Michael, thank you for joining us. And myself, I've been a registered patent attorney for 29 years. I've been with Fishman Stewart since 2007. And I work in IP litigation, IP procurement, as well as develop IP strategies for startups, companies, VCs, and private equity firms. So let's get into the heart of our question session here today. Let's just go around with an initial open question, if we can. And we'll start with you, Melissa. We've been seeing a lot of pressure being put on by our clients. And they're reacting with respect to how to save cash, which is kind of a focus of our conversation here today, about how clients can save cash yet still protect their innovations. So can you tell us what you are seeing right now, Melissa, with your clients, and how are they responding to the COVID-19 crisis?
Well, I mean, you hit the nail on the head, Doug. You know, our client, I'm sorry for the background noise, by the way. But you hit the nail on the head. Our clients are, you know, looking for innovative and effective ways to uh, minimize the spend right now while we weather this storm. And so we're working with our clients in many different ways, which we'll kind of dive into later on how to accomplish this.
Okay. Paul, from a patent perspective, how are you seeing clients respond right now to the crisis? What kind of things are they doing?
Yeah, what we've been seeing is a lot of clients have been reaching out to just take immediate extensions if extensions are available. That can be in your foreign prosecution, it can be in your U.S. prosecution. They're just looking to immediately stop the cash flow, while of course looking to preserve their rights long term, so that once the things settle out, they'll be able to come back and pick up where they left off. So that's the immediate thing that can be taken, that clients are taking right now.
Right. Okay. Are you in both Melissa and Paul? Are you seeing a lot of activity with respect to clients needing extensions and things like that?
Well, as we'll talk about in a minute here, there are extensions available from the Patent Office. The Patent Office came out with these directives recently, one of which is where they're offering up no-fee extensions for both patent and trademark pending applications. And so if you fall within a certain time period between March 27th and April 30th, the Patent Office came out with recent directives that said you can, if your business has been impacted by the coronavirus thing going on, that you can just take these extensions for no additional fee, and by just representing that your business has been impacted and then you can pick up after a month.
Right. Right. And Melissa, on the same point, from the trademark standpoint, I don't want to jump too far ahead, but from the trademark standpoint, have you seen clients that are reaching out to you trying to delay the trademark burn rate as far as cash flow burn rate?
Yes, definitely.
Yeah. Okay. Michael Fluhler, can you, your focus is dealing with clients in the area of counseling them on how to deal with times of crisis, dealing with crisis matters. I know in your past role as in-house counsel at a medical device company, you focused on patent procurement, things like that. What kind of things are you seeing clients are asking you about these days in view of the crisis?
Yeah, thanks, Doug. Step one is the question, do you have a policy in place to address some of the typical areas of concern? I would look at, confidentiality, trade secrets, what are our existing policies doing to address those kind of things. Also, non-compete, non-solicitation type concerns. And then also a big one is the ownership of the IP. So question being, does your existing policies address these kind of things? And then moving towards more workplace adjustment type of things. Are there being severance packages deployed? Are there layoffs? And depending on the specific circumstances, this is typically a good point to present the checklists, or if there's some kind of consideration on the employee leaving the company, what can be done to tidy up any confidentiality concerns, non-compete, and ownership issues, and as well as associated documentation of who owns it in terms of signing any kind of assignments or anything, essentially closing the gap on a lot of the IP items currently in your policies, as well as you do those kind of workforce adjustments.
Okay, we'll get back to a little more of that, Mike, on workforce kind of adjustments that can be made. Melissa, I want to follow up with you next on a trademark specific question, and that is, how can I, as let's say a company with a book of trademarks that need to be maintained, how can I delay the cost associated with maintaining my trademark portfolio? This would be relevant to someone with maybe 5 trademarks or 500 trademarks. So what are the things that you're seeing right now?
Yeah, well, that's a great question, and that's a very common question that we're seeing right now. And there's a few things that you can do to minimize the spend or kind of push the spend down the road. The first thing is to look at your portfolio and first determine, do you need to maintain everything? If you're thinking about phasing out a brand in another year or so, maybe you do it a year early, at least in terms of, you know, protection to save the costs associating with maintaining or renewing that registration. Another strategy is to kind of pare down your protection so that you're only protecting your core goods. So for example, if you're a restaurant, maybe you're protecting restaurant services and t-shirts. And if you have to, if we're trying to save costs, maybe we choose not to continue to maintain t-shirts because it's not your core business. Another thing to look at is in many countries in the US and around the world, there is kind of like a grace period to maintain your registration. And there's often a small fee associated with taking advantage of that grace period, which is usually 6 months. It's usually a couple $100. It varies by jurisdiction. But that's another way that you can maintain your current portfolio at least for another 6 months, so we can hopefully get through this and kind of reassess to decide, you know, what are we going to do? And then the last thing that I wanted to point out, you know, we kind of talked about what the US Trademark Office is doing in terms of extending deadlines, but every trademark office around the world is kind of doing their own thing. And so although here we may not have more than a potential 30-day extension, in other jurisdictions there may be, you know, significant relief. And so working with your counsel and your foreign counsel to kind of identify your options is key.
Let's one follow-up point on extensions for the trademark office. How does one go about that, and is there any fee for that process?
In the US, the 30-day extension or kind of prolonging your deadline, there's nothing you have to do other than file your paper within 30 days and provide an explanation as to why you were affected by COVID, which, as Paul mentioned earlier, right now it appears to be a relatively you know, broad standard, you know, cash flow issues, if somebody is sick, if you're looking after your family, that kind of stuff.
Okay, good, thank you. Paul, could you follow up on that specific question I have about the patent office for getting an extension for filing response or something before the patent office? What is that process, and what should our audience understand about that process?
Yeah, so the Patent Office in recent weeks came out with 3 directives. One of them was on March 16th, where it was directed toward patents and trademarks that become abandoned as a result of something related to the COVID-19 outbreak. The other 2 directives came out on March 31st, one directed to the patent and one directed toward the trademark side of things. And for the patent side of things, for instance, how do you take advantage of this? Well, as Melissa alluded to, if your business operations have been impacted by the COVID-19 outbreak, the bar is very low to qualify for this. And you get a no-fee extension that you can just take after the fact. You don't have to take any action on the patent side right now, and just later you can take advantage of the opportunity by representing that your business was impacted by these conditions, and then you can pick up where you left off later after you've had that extension.
Okay, good, very good. And I want to ask you a similar follow-up question on the patent side of things, Paul. What kind of low-cost options can innovators implement today to reduce the cost yet still protect their company's innovations?
Well, the first thing they can do, if they have a pending portfolio of patents, they can just plan right now to just stay the effort, take the extension. If they've had this cash flow impacts and whatnot, they will be able to defer those costs till later. And along the other lines, if your company continues, as your company continues to innovate, you have options available. As always, you have the option for a provisional filing. So if you file a provisional patent application, you can do so in short order. If your company is putting together technical documents, presentations internally, technical papers that are being written, these provisionals can be filed in short order and preserve your priority dates so that you can pick up where you left off. So if your company doesn't normally file provisional applications, it's something you might consider doing now just to preserve that date and be able to pick up and review things later.
Okay, all right. Michael Fluhler, we're talking about companies that may have trademarks that are already in the pipeline and pending or registered, and then Paul spoke about what can be done from the standpoint of protecting patent applications and getting extensions with respect to patent applications. My question for you focuses on maybe companies that have new products that are in the pipeline. We've seen a lot of examples in the last few weeks, and here's a few examples of new products being developed, new mats, new ventilator systems, a lot of testing treatment technologies are being developed right now, delivery services, companies coming up with new social apps. Zoom is the big thing now. They're overwhelmed with people using at-home technologies. 3D printing is big. People are using that in lots of different ways. So with respect to companies that are developing new innovations, unfortunately, some of these companies may be laying employees off. And some may be, hopefully they'll be coming back and joining the workforce, but some may not be coming back and due to the COVID-19 crisis. What are some things that you would suggest from the standpoint of when key employees leave, how can they best situate themselves to still protect their new innovations?
Thanks, Doug. A lot of this comes down to internal policies that help promote good practices. So kind of going through the items I briefly highlighted before, the first one being confidential and trade secret information. The key is to setting up internal policies that categorize what is confidential to your company. These aren't just the generic laundry list of types of confidential information. These are the specific confidential aspects of your business that would damage the business if it was disclosed. And then above and beyond that, what's the short list of trade secret items? These are the kind of items like a CocaCola recipe that they keep in a vault, the things that are crucial to the business, that if those specific pieces of information were leaked, it would significantly damage the business. And so setting up internal policies as categories of the types of confidential information and listing specific types of trade secrets keeps the employees aware of what's sensitive to the company. And also when those trying to lay off transition types of issues, it's a good point to remind when offboarding employees to respect a lot of those categories of confidential information and trade secret items. And really quickly going through the non-compete and non-solicitation obligations. Again, making sure policies, contracts, and all those contemplate things that are realistic and reasonable for your business. In terms of if it's a rapidly evolving business, the time frame may be shorter, the geographic scope may be different, and then also the type of scope in terms of the types of activities that are prohibited may be different. So it's all custom fit for your company, but the key is laying those out. So when the layouts happen, everybody's on the same page on what is to be respected, the bounds of future activities. And then the last item is ownership issues. This is one that comes up very frequently. So this is internal policies, checklist offboarding, things that remind employees of who owns the intellectual property information and everything related to the business, and be fair about it, because if they're developing things entirely unrelated to the business, the company may not have no rights to those things. And then as you transition to workforce adjustment type of issues, reminding the employees that are offboarding of who owns intellectual property related to the company. And also there's a good opportunity to have them sign any kind of documents that would tidy up ownership, such as assignment documents and things like that. Or at least, if they're unwilling, identify the associated risks so you can manage the business accordingly.
Thank you, Michael. You'd mentioned, I'm going to come back to this, but the next time it comes around to you, Michael, but you mentioned the word trade secrets a couple of times. I think it'd be nice maybe for you to give the audience a backdrop about trade secrets, but I'll ask you that question when we follow up in the next kind of round robin here. So I want to move on to Melissa now, our trademark expert, and ask her a question about enforcing brands worldwide and how to protect brands worldwide, specifically about any kind of cost-effective measures a company can take with respect to how to protect their brands worldwide in a cost-effective way. Any suggestions on that particular type of scenario?
Yes, there is a very effective way to do that. Basically, you can file here, or if your business is located in a different country, you file in your home country now, and then through an international treaty, you can basically extend your ability or your ability to file in different jurisdictions and still get your US filing date. So basically you get in line in the US, you don't have to file around the world for 6 months, but you still get the same spot in line. And so the implication is that right now we only have to spend the money filing here. 6 months down the road, we have a better picture of how things are going to work out. And so then at that point, you can decide where you want to file, how you want to file, and how much money you want to spend. So it's just another way to move things forward without a lot of spending a lot of money. I also just really quickly wanted to follow up on my last my last little discussion. And if you do want more information about the USPTO's extensions, the 30-day extensions that Paul and I both talked about, there's a section on the USPTO website, and it's uspto.gov/coronavirus, and all the information that we talked about is there if you need further details.
Okay, good. Thank you for that information. And also to follow up on that, as a follow-up to our conversation here today, we will send out a follow-up email to the attendees who have signed up. And Paul and some of our fellow team members this past week put together a short little summary of the USPTO's new guidelines in view of the current crisis. And we will make that available to our participants if they'd like to get that. They just need to let us know about that.
Well, and I also will just add that it's available on fish2ip.com. If you go to that spot, you can see that we had a recent our recent summary that we put out last week is available, and that's got a short summary of the 3 directives that I mentioned.
Yeah, and on that point, Paul, is there any indication that the Patent Office might do anything more than what they've done as of last week, or don't we know, from the standpoint of providing relief to our innovators?
Yeah, that I think is the key question. I think at this point, the shorter answer is no, and we haven't gotten any indication. I just looked recently at the website that Melissa mentioned, and there's no further activity. There are a few other notices that are coming out there, so it's worth watching. But at this point, there's been no indication of further extensions of the already issued directives, of further directives. But we'll certainly be watching that, and as they become available, our firm will put out further notices of these as appropriate.
Yeah, and in your experience, Paul, have you ever seen the Patent Office take this kind of action before?
I have not. You've been practicing much longer than I have, but I've been at it long enough also to see. The one thing I think that bears noting is that the Patent Office has certain latitude to grant these extensions and things like that, and to the extent that they can, they will provide relief, especially to small inventors. companies that get relief from both costs and the time frame, but they also have certain limitations. So if we have statutory bar dates that are coming due, we can't expect any kind of relief from that from the Patent Office. They just, I don't even think they have the authority to do such thing. It would take an act of Congress to do something like that. But there is further relief that might be available that's within the control of the Patent Office, and we'll be watching that.
Right, good, okay. And while I'm still with you, Paul, I had a follow-up question similar to Melissa, but on the patent side of things. Are there things that inventors can be doing now, companies can be doing now from the standpoint of reducing patent prosecution costs and defer them for maybe 6 or 8 months? Is there any practice tips there you can share with us?
Well, as we talked about, you can immediately take extensions. Just plan to take that. We don't need to take any immediate action on a client's behalf, and we can, after the fact, represent as appropriate that extensions are available that are taken due to the COVID-19 outbreak. But beyond that, also the immediate steps that can be done is if you would normally be filing normal full utility patent applications, and you can simply file provisional patent applications right now. You actually can file them even without payment of the fee. You can just do that, no fee. You'll establish a date. You'll incur a surcharge later for not having paid that fee up front, but that's something that can be done for a no-cost option right now. Get a notice later, so you can still establish those priority dates if you continue to innovate.
Oh, that's a good point. There, Paul. That's another cost-saving measure that inventors can take today and still protect their innovations. Michael, turning back to one of your points a little while ago, you mentioned about using trade secrets and trying to protect innovations. We've been primarily talking about cost-saving measures with the Patent Office, what they're doing with trademarks and patent application filings. With respect to trade secrets, can you briefly give us a brief definition of what a trade secret is for our users, and tell us how, in times of these particular times, how individuals can be using trade secrets to still protect their competitive advantage, but still not be paying any fees to the Patent Office or anything like that. In fact, there's nothing to even file with the Patent Office when it comes to trade secrets. Is that right?
Right. So the big upside of trade secrets is there's no filing fees. It's no government fees, and really it's the internal resources to maintain the policies in place. And so, stepping back to your original question, is to lay the framework of this is what is a trade secret? A trade secret is defined as information that is secret, first prong, so it can't be publicly known or kind of well known in the industry. It probably shouldn't even be disclosed to other people other than under confidentiality or trade secret agreements. Second one is that reasonable measures have been maintained to keep this secret. So you have policies, you have procedures in place that make sure it stays a secret. And the last one being is that there's independent economic value created from it being secret. So the difference there is if there's no economic impact on it being disclosed versus secret, it's no change in the value proposition. It's not a trade secret. And then the last being to enforce trade secret misappropriation, the trade secret information has to be acquired by improper means. So you can't fault somebody for disclosing your trade secret information every which way if you allowed them to acquire it. And one additional note is a lot of stuff that comes up is sometimes trade secret information gets sloppily merged into typical confidentiality agreements. And that's dangerous from the point of there's a lot of decisions that require eternal vigilance for trade secrets. So trade secrets is supposed to be that company critical information. And so if you're treating it like run-the-mill information, lumping it into an NDA, typical non-disclosure agreements have a shortened term there's a number of decisions that say if you treat it that way, it's not a trade secret. It's not enforceable. So in terms of policies and things you can do to help maintain that, essentially maintaining the chain of custody for trade secret information. If you have top 3 pieces of trade secret information, you probably have 3 times as much as the typical company has. It's typically that high value information that's going to destroy value behind a major product line or something. So chain of custody is key. Where is it stored? You have policies in place that restrict transmission. Who has access to it? Is it the CEO, the director of R&D that has access? Or is it just accessible on a computer, on a shop floor, connected to a printer, and anybody could print off the information and bring it home? So it's a lot of those type of protocols. And then if there is misappropriation, the same things are revisited as your reasonable measures for maintaining secrecy. So if you have all these things in place, there's a pretty strong chance that you could actually enforce and do things about trade secret misappropriation. If it looks like everything's trying to be retroactively created and trying to fix a situation that was never treating the information as trade secret, your chances are very low in obtaining any kind of relief.
Very good. And one just little tidbit for our participants today, the most famous trade secret that we're all probably aware of is the Coca-Cola formula. Coca-Cola goes to great lengths to try to protect that trade secret and keep it a trade secret. And another thing I'll just add on is the trade secret lasts until it's no longer a secret, so it goes on in perpetuity. So it's a pretty powerful intellectual property tool that we have in our toolbox that we can use, especially this time when you're trying to save cash. Paul, I see there's a question that one of our participants raised about can they file a utility application? You were talking about filing a provisional application with no fee up front. Can an inventor also file a utility application without paying the fee up front? And if so, what are the pros and cons?
Yeah, so that was a good question that came in. The distinction is if you've already been in the process, or if you still desire to file a full utility patent application, you can do so, and you can even do so like the provisional I mentioned without the filing fee. You get the fee later. So maybe you have an applicant who was already most of the way done with having their attorney or prepare a utility patent application, and now they're faced with a no cash flow. We still want to file this. Well, you could file it as a provisional application and buy time to complete the application. You buy yourself a year to file that provisional. They're, in general, less expensive to prepare and file. You'll have less fees that you incur, just the amount of time that it takes to prepare them. So the balance is there that you can file that provisional now. You can file the utility now and not pay the fee. And later you can come back and get that surcharge pay later. That's just for a true stopgap to just stop the cash outflow of what you're doing. The benefit of that provisional, why I kind of focus on that, is because it is a quicker, low-cost option that you can consider now. But of course, that utility is still available as an option as well.
Okay, very good. And I believe there's another cost-saving measure for individuals filing patent application, and that falls on the category of micro-entity. How much can that potentially save an inventor if they file under the micro-entity status?
Yep, that's a good point. And a micro-entity has certain qualifications that if you're an individual inventor, you've had only so many patents that you've ever filed in your life, and you hit certain income, that you stay below certain income thresholds that are tied to a certain income requirements based on government requirements for such things, you get a quarter of the cost of what a large entity will file. So a corporation is typically a large entity. You have a small entity, which is typically 500 or fewer employees, that get half the filing fees of a large entity. And then this relatively newer entity called a micro entity is directed toward the individual inventor who has limited resource, and they can certainly take advantage of that option as well. And so now you're looking at filings that can be very low cost for small inventors that can jump right into the game now and even defer those costs later, like we talked about.
Right, good. Thank you, Paul. I see we're at the 35-minute mark, and I think I'd like to move towards kind of transition towards the end of our conversation here today with our panelists. And I just want to throw out a basic question for all of you to kind of weigh in on, and that is, what are your final thoughts that you'd like to share with our viewers here today on what should be done regarding saving cash, yet still working hard to protect their innovations? They need to keep their competitive advantage, and coming out of this crisis, hopefully within a month or so, could be a little longer, we don't quite know yet, but there is a light hopefully at the end of the tunnel for a lot of our innovators out there. We want them to keep their competitive edge. So Melissa, I'll start with you first. What are your final thoughts that our viewers should take away here today?
I think just what I've said before is just delay if you can. And I think I've outlined some different ways that you can do that by yourself, maybe 6 more months. And, you know, what we're doing right now is we're helping our clients figure out how to basically triage everything. And so that's something, you know, that we can certainly do for our attendees.
Okay, thank you. Paul, any points you would like to share with respect on the patent front?
Yeah, the very first thing you can do is just take no action if you're not facing a bar date. Take advantage of the patent guidelines that have been issued. Find out if there are other things available. For instance, if you have foreign prosecution going on, there are a lot of no-fee options in foreign venues that you can do. And if you're aware of that, you can just say, look, take no action at this point. Let's buy ourselves the time, take advantage of the USPTO, any foreign things. File now. If you have something that you're really concerned about, file a provisional, don't pay the fee. Buy yourself that year to come back and reconsider how you want to approach this down the line.
That's good advice. Thank you, Paul. And Michael, from a business kind of management standpoint, what are your takeaways here today? What thoughts would you like to share with our audience?
Yeah, thanks. I think today we've identified a variety of mechanisms to help protect intellectual property. And so I think it's key to understand and identify what you have right now. And it could be you list them out and then figure out how that aligns with your current products, competitor products, the CV19 scenario, all of that. And then the last step being is how do you align all those types of intellectual property with where the business is going, and how can those things help the business both survive this and also hopefully end up on top after things return to normal.
Good. That's a good point. Thank you, Michael. This concludes the Q&A part of our panel discussion today. We've had some questions from the audience. We thank you for weighing in some of those questions. And we want to thank our panelists for the time and efforts here today. It took some effort this past week in getting this put together. I want to thank you both for your time and attention for this, and also for providing our viewers with some practice tips for navigating this crisis. We hope you learned something new today that your organization can benefit from our discussion. And we will be broadcasting this again. It's not going to be recorded. We are recording this, by the way, but we will rebroadcast a live panel discussion this coming Thursday, 1 o'clock Eastern. If you click on the link that you received from our email blast last week, there's a tab there to click on for Thursday's webinar. We're going to improve a little bit here. We're going to improve by taking some of these questions that we received from our audience that we didn't get to and add them to our conversation here today. So please pass on information about our webinar to a fellow colleague that might find this of interest. Our goal here is to help the entrepreneurial ecosystem, and all of you are part of that, and we appreciate your time and attention. During this webinar, we announced a couple of USPTO announcements. Paul and Melissa spoke to those regarding cost-saving measures with the COVID-19 crisis. Fishman Stewart has some follow-up information about the recent cost-saving measures. You'll find them on our website at fishstewip.com. If you want more information about our panelists, you can find their information in their bios on the link we sent out last week that included part of the email blast for this. So feel free to email them directly. They'll be happy to reach out to you and answer your questions. Fishman Stewart, as we're alive and well, or we're running on our platform. We're all working remote. We've been working remotely for about 3 weeks now, and we're running well, and we're up and available for business. So this concludes our webinar. Please stay safe and abide by the CDC rule guidelines. We need everybody to pay their part to get through this crisis. We wish you, your team, and your family the very best during this crisis. Thank you so much, and this is the end of our broadcast. Have a great day.